All rise. Court of Appeals, Division 1 is now in session.
Good morning. Thank you. You may be seated. We are here this morning in our case number 1, CV140850, Compass Bank versus Robert and Marilyn Bennett and the Bennett Family Trust. Each side will have 20 minutes for argument. Appellant, obviously, if you want to reserve some time, you'll have to do that on your own. We have conferenced this matter. We've read the briefs. We're familiar with the facts. One other point, these proceedings are being audio and video recorded, so please announce your name and your client each time you appear or when you approach the podium. And with that, we look forward to your argument. Your Honor.
Thank you, Your Honors. William Kozub and my partner Daniel Kloberdans for the Bennetts, Mr. and Mrs. Bennett, and the Bennett Family Trust. We are the appellants in this matter. We are appealing a motion for summary judgment in the trial court that was entered against us based on what we believe to be a pure matter of misinterpretation of the law by the trial court. I understand you know the facts, but quickly, this case arises out of Arizona's anti-deficiency law scheme. The Bennetts borrowed money from the appellee, Compass Bank. It was a second position loan. It was non-purchase money, but the collateral for the loan, secured by a deed of trust, was a piece of property that was less than 2.5 acres and utilized as a single family home. So the property is squarely under the anti-deficiency protections provided under 33814G. However, under the mortgage foreclosure laws, it does not meet the purchase money characteristic. We begin in 1971 when Arizona passes the deed of trust statutes, including the anti-deficiency laws. As the Arizona Supreme Court has said in Baker versus Gardner, which is still the controlling case on this subject, and which is the language of that case which brings us here today, that original Supreme Court decision said any loan that was 2.5 acres or less, single or double family residential dwelling, and secured by a deed of trust, the legislature effectively abolished liability of the borrower. And if that was still the law today, we would not be here because Compass could not have sued the Bennetts on this loan. However, oddly, a unique occurrence, the Arizona Supreme Court revisited the Baker decision and issued a supplemental opinion. And in that opinion, the Arizona Supreme Court followed the interplay between the deed of trust anti-deficiency law, which again is limited to 2.5 acres or less single or double family home, and the mortgage anti-deficiency law, which applies those two standards and needs the loan to be purchase money. And in the Arizona Supreme Court case, Justice Feldman held there was an exception to the blanket prohibition provided in the original opinion. And that exception was that where a lender, even though a lender is barred from pursuing a deficiency if they pursue a trustee sale, if they pursue their remedy under the judicial foreclosure statute and could preserve a deficiency. So remember, not all judicial foreclosures preserve deficiencies. A deed of trust may be executed upon by way of a judicial foreclosure, but still there is no right to a deficiency depending on the characteristic of the loan. But in some cases, a judicial foreclosure does allow a lender to obtain a deficiency. And so in Baker versus Gardner, the Arizona Supreme Court said, when a lender could pursue a trustee sale, they have a deed of trust, or they could pursue a judicial foreclosure, and if they pursued the judicial foreclosure could preserve a deficiency, they have a third option. And that third option is cited in our brief at page 19 of our brief, and that's the quote from Baker versus Gardner. That's on page 107 of the Baker versus Gardner decision. It's a 4-sentence paragraph entitled Summation and Application. So what I'm about to tell you is not the dicta of the case, it is the holding of the Arizona Supreme Court supplemental decision.
Didn't Baker involve a purchase money security interest?
It did, yes.
So when you say holding, help me understand what you mean by that.
So the original Baker versus Gardner decision, not the supplemental decision. When I say the original, I mean the 1988 decision, not the 3-month later decision. It ruled that whenever a loan is secured, whenever a piece of property that's 2.5 acres or less and a single or double family home, whenever that piece of property is secured by a deed of trust, a lender may never pursue a deficiency. That the legislature has abolished personal liability. So the supplemental opinion was because the court said, oh, now wait a second, that decision doesn't take into account 33-729, which
wasn't it, if I remember right, wasn't it sort of amici or industry groups said, wait a minute, you've painted too broadly.
For sure.
And the supplemental decision then charted out some ground, but the holding remained unchanged on those facts.
Well, the holding did change.
The supplemental decision didn't alter the outcome of the Baker case.
It did not alter the outcome to the Bakers,
right.
But it did alter the outcome of the law. The original Baker decision stood as a total prohibition to what our instant case is about.
And what I understand what you're saying, and I don't want to detract or take you down a path that isn't helpful to any of us. But when you said holding, that's what I struggled with, because the supplemental decision charted out some territory, but the holding for the parties remained unchanged.
Yes, the outcome for the parties remains unchanged. However, the paragraph entitled, and we've cited the authority in Arizona that says even if you think something is dicta, and by the way, our position is the clause we're talking about is not dicta because it's cited 12 times by the Arizona Supreme Court, and it was cited by this court multiple times in the RTC versus Siegel matter. So we're not talking about a word somewhere. We're talking about a sentence, a clause that has several action verbs that was repeated repeatedly by the Arizona Supreme Court and subsequent courts of appeals.
Has it been cited outside the anti-deficiency context?
So I'm not sure how to answer that question, Your Honor. Because the topic of this case is a very narrow subset in the world of lending. So the anti-deficiency laws only apply to a small subset of loans made in Arizona, as evidenced by the public policy in Baker versus Gardner and the Helvetica decision from this court several years ago, that the public policy is to protect borrowers from their assets other than their home being executed upon. The public policy is to place the burden of overlending, and we all know what overlending does to an economy, evidenced by the last 10 years.
But isn't that in the context of purchase money loans to buy real estate? If someone comes in and just wants to borrow $300,000 to buy a luxury boat, it doesn't seem to me the anti-deficiency provisions really affect that in any way, that there's not a public policy in favor of, we want to protect some security that someone wants to put up for a loan.
Yes. So I would answer that this way, Your Honor. And with all due respect, I think you're having too narrow of an interpretation of the legislative intent as this court and the Arizona Supreme Court has found of the anti-deficiency law. So first, yes, the Arizona anti-deficiency law says if you borrow money to buy a boat, and the rest of the cash you burn in a ceremony in your backyard, that loan is still protected by the anti-deficiency law if that lender executes by way of a trustee sale. So the trustee sale, 2.5 acres or less, single or double family dwelling, does not matter. It does not matter to the analysis and application of the anti-deficiency law in that setting what the loan was used for. It's important to understand, again, I keep mentioning public policy, but there's several big issues here. A trustee sale is a non-judicial process without nearly any due process protections. The courts are not involved, no service is required. You can effectuate a foreclosure merely by sending certified mail that comes back. The homeowner never needs to know. A judicial foreclosure is through the courts and does require a heightened sense of due process for the borrower as opposed to the trustee sale. And that is why there's a different anti-deficiency law, because the theory is you need more protection in a non-judicial process, in a no due process than you do in the judicial process. But back to your specific question. One, the anti-deficiency law does apply in a trustee sale regardless of what the money was used for. And this is why I think it's important to note that the anti-deficiency law is not limited just to the purchase of the house. The public policy of the anti-deficiency law is that the lenders, between a commercial land developer and a lender, their knowledge of the marketplace may be similar. But between the individual homeowner, the consumer, the small party, and the lender is in a better position to know the market value, a better position to know the extent to which they should lend. And we put, as a matter of public policy, we're putting the burden on the lender in those situations to not over-lend, because over-lending damages the economy. And the concept there is put the risk on the party best able to bear the risk and avoid the risk. And that's why the anti-deficiency law only really protects the consumer.
But here, if the only thing the lender has to do is say, I'm not going after the security, I mean, you would agree that under that, if I expressly waive my right to go after the real property that secures the loan, if he just says that, there's nothing that keeps him from going directly against the borrower. Do you agree with that? Isn't that
maybe?
your argument that you have to expressly waive?
Yes. So I say maybe based on the words in your question. But our belief is they have three choices. They can do a trustee sale, they can do a judicial foreclosure, or they can waive their collateral and sue on the note.
And isn't that what happened here?
No, in fact, that's expressly what did not happen here. The lender made no effort to release their collateral, and in fact, at oral argument.
Well, but didn't they? I'm not aware that a waiver requires a use of precise words, I waive my rights. If you don't exercise your rights, isn't that a waiver?
Well, no, I do not believe that is a waiver. And let me explore this in greater detail. Arizona Revised Statute Section 12-1566 specifically provides, not in the anti-deficiency context, but in the broader context of all loans, that when a lender wishes to sue on the note, and waive their security, that statute provides a very definite statement. At the very last sentence of that statute, it says, abandonment and release shall be evidenced by a recorded release of lien.
That's F, right?
I'm sorry,
F.
Your Honor?
12-1566F.
F, that's correct.
And that statute has no application here, correct?
So it indirectly has educative...
And let me tell you why I say
Yes.
that, because it is titled Execution Upon Judgments for Debts Secured by Real Property, which is not what we're dealing with here. And
yes.
Your both opening and reply briefs don't cite the statute.
That's correct, Your Honor.
Sort of guessing that's not the linchpin.
So and I'm not trying to say that statute is controlling. I'm trying to say that statute is educational on the concept of what goes into effectuating a release.
But doesn't that, let me flip that on its head, because I understand your position, but doesn't the fact that that exists in this statute that doesn't apply suggest that that is not required here? Because there is no statute that contains that.
No, in fact, I would say we're putting the cart in front of the horse on this. Remember, that statute applies to the general rule of commercial lending, the entire world of loans and releases, et cetera. What we're dealing with today is a subset.
For execution upon judgments.
Yes. Okay, that's the title of the statute.
Which is not what the question here was, do you get a judgment, not how do you execute it?
That's right. So, but back to the concept of, to answer the first question of yours, this is a very narrow area of Arizona law. Very little controlling authority exists on this. We have the legislative intent. We have the Arizona Supreme Court's original Baker decision. We have the Arizona Supreme Court's supplemental Baker decision. And in that decision, the court repeatedly said he may elect to waive the security. Elect to waive the security.
Back to my question.
Yes.
What exactly, if you fill out a piece of paper that says, I elect to waive my security, and you record it somehow,
Yes.
that you've made that election. So you're saying you have to put something in writing and record it? Is that
Yes.
is that your position? But I'm having a hard time squaring that with how that advances any public policy. It seems to me that it goes more to the lender's ability to go after the property. If they don't cross all their T's and dot all their I's, then they don't get to go after the property. But if they go after the loan directly and they haven't, then that's going to be a waiver, and they're not going to be allowed to go after. I mean, seems to me you might be making that argument if someone goes after the loan and they don't have money and they haven't properly preserved their right to go after the asset that secures it. It seems like it's a protection for the lender as opposed to a protection for the borrower in this instance, where anti-deficiency is not in play.
Yeah,
Sorry
so,
for the long question.
Your Honor, I would take this holding from the Arizona Supreme Court to be an express protection of the borrower, not of the lender. The concept of waiving the security and pursuing on the note does have public policy implications. As the lender has admitted in the record, as long as they hold their deed of trust, they hold certain rights. So they are both holding the bag of rights that come with pursuing a lawsuit while preserving the bag of rights that come with holding a secured lien. If they were to release that lien, they no longer have a claim to excess proceeds. It now becomes easier for the homeowner facing a foreclosure on their first position deed of trust to refinance the property and save the family home. There are any number, and we've outlined some of these in our brief, there are any number of public policy implications that are pro-consumer that come from requiring a formal release of the deed of trust. Now, specifically how that release would occur, I'm not here to tell you that. I mean, I would like to see, like a Liz Pendens on a mechanics lien case, I would like to see that release recorded contemporaneously with the filing of the lawsuit. But perhaps the notice could be in the lawsuit. Regardless of how that release would occur, it did not occur in this case. The only action taken by the lender in this case was a refusal to take any action. And the Arizona Supreme Court used the words elect to waive.
Well, because if the lender goes on the note rather than the property, if they subsequently do try to exercise some right that would otherwise attach to the secured interest on the property, can't the borrower just say, hey, you've waived that because you went after me on the note, not on the property, and then everything will come out as it's supposed to come out.
Yes. So, and there's a case on, there was a statute that was misinterpreted and has subsequently been clarified by case law. But to the extent your question is asking, do we somehow impact the creditor's judgment lien rights by requiring them to first release their deed of trust? The case law is clear. The answer to that is no. So, but the purpose is so that when they get their judgment lien, it is not part of the deed of trust. The lender has to make that election. They have to elect to either pursue remedies based on that consensual security instrument, or they have to waive the security, sue on the note, and live with their judgment lien.
But my question was, how is the borrower harmed if they can argue that, hey, you lender waived your right against the property by going after me on the note, and the borrower or your client is harmed then?
They are, the position of being a lender holding a judgment lien versus a lender holding a consensual lien is fundamentally different in the law. A consensual lien is non-dischargeable in bankruptcy. The non-consensual judgment lien merely places the lender in the same position as all the other unsecured creditors. So that is why in this consumer protection law, the Arizona Supreme Court limited the lender's rights to trustee sale, in which there would be no deficiency regardless of the nature of the loan, a judicial foreclosure in which there were anti-deficiency protections and a judge overseeing the entire matter, or you must elect to waive your security and sue on the note. It does not say sue on the note solely.
Let me ask you a hypo.
Yes, Your Honor.
In this case, as I understand it chronologically, the trustee's sale on the first position is noticed. This case is filed.
Yes.
The trustee's sale on the first position occurs, credit bid, then your clients are served. Is that fair?
I believe they were served prior to the trustee sale, but
I have it as after by a couple weeks, according to the record. But what if instead, with the recording that you're advocating, the second position did nothing, allowed the trustee's sale to go forward.
Yes.
On the first, the next day, they record a notice saying we waive any right under our deed of trust, which is worthless by that time anyhow, and then file the same suit.
Thank you, Your Honor. That's an excellent question. First, we are not here saying they have to release their security if the security has been released by the foreclosure of a senior encumbrance. We accept and have not argued contrary to the belief that all deeds of trust are analyzed separately under the law. So in your scenario, once the first position lender has foreclosed, there would be no need for Compass Bank to record a release because the deed of trust has been released as a matter of law.
So your argument is effectively, stated differently, I don't hear you making it this way, they sued 2 weeks too early.
Yes, Your Honor.
And if they sued 2 weeks later, we wouldn't be here at all.
Well, we don't know what would have happened in those 2 weeks on the day they sued, but in hindsight, that is correct. And I would like to reserve my last 25 seconds. Thank you, Your Honor.
Good morning. May it please the Court, Bradley Pack appearing on behalf of the appellee, Compass Bank. What the appellants are asking this Court to hold is not only that the holder of a non-purchase money deed of trust has an affirmative obligation to release its deed of trust as a condition to suing on the note, but also that if that non-purchase money lender doesn't affirmative release, it has thereby extinguished its right to file a lawsuit on the note. But where does this rule come from? You're not going to find it in any statute in Arizona, and the appellants haven't cited to any statute that would impose such an obligation. You're also not going to find it in any case law in Arizona. Instead, the appellants are asking this Court to infer such a ruling from dicta in the Arizona Supreme Court's supplemental decision in Baker. And as Judge Thumma noted, that wasn't the issue in Baker. The entire issue in Baker was whether a purchase money lien holder can circumvent ARS 33729 by choosing not to foreclose its purchase money mortgage and instead suing directly on the note. Nothing in Baker discusses, let alone requires, the issue of whether a non-purchase money lien holder has to do anything.
What instruction does Siegel give us on the application of Baker to this case? At least as I read Siegel, it talks about that language and ultimately concludes, and I'll quote, "This court must follow the direction given by the Supreme Court in Baker."
Well, and I think what Siegel holds, Your Honor, is that Baker has no application to non-purchase money lien holders, that a non-purchase money lien holder is free to choose not to foreclose on its deed of trust and instead to sue directly on the note. And as long as it doesn't conduct a trustee sale foreclosure, it has the right to do so and can obtain a judgment on the note.
But that gets us to, sort of the last sentence, where the creditor can obtain a deficiency judgment. He can also elect to waive the security under 33722 and sue on the note. And the real issue there, I think, is what elect to waive means.
Right, and I think that's what the appellants have based their argument around. What their argument is the word waive in Baker has one and only one plain meaning, and this court has to apply that meaning. Well, first of all, Baker's not a statute. They're using canons of statutory interpretation, and they're trying to apply it to a judicial opinion. And I think it's pretty clear that judicial opinions have to be read in the context of the facts under which they arose and the specific holding
In
that the
your
court
view,
made.
if the lender, if your client had gone directly, had just filed the lawsuit, notwithstanding anything that's happening with the security, gets a judgment against the borrowers, is there anything that keeps the bank from also then pursuing the security?
I don't think that there is, Your Honor. I think that you can, in fact, file, if you've got a non-purchase money note, you can file a lawsuit on the note and then also pursue your security. I don't think that's an issue that's presented in this case, so it's not
I think the waiver only applies if we're talking about a purchase money obligation.
No, I think what I'm saying is that the word waive doesn't mean what the appellants are suggesting the word waive means. What the appellants are saying the word waive means is basically permanently release your right to do something. In this case, you've got to permanently release your deed of trust on the property. You've got to record a release and reconveyance. But that is not the sense in which the Supreme Court used the word waive in Baker, and it's not the sense in which any of the cases following Baker have used the word waive. I think as Judge Howe had noted, the word waive is commonly understood to mean not to exercise a particular right. It doesn't necessarily impose an affirmative obligation on anybody, but it's simply an obligation. It simply means not to do something.
Counsel, let me ask you, and I understand, waive can mean many things, from an intentional relinquishment of a known right to simply allowing a deadline to pass. And depending on what context you're in, that's where you are. But the phrase is elect to waive. What does that mean? It seems like that adds something to the discussion.
Well, I think that the appellants would like this court to interpret the word waive as meaning you have an obligation to choose one thing or another to the permanent exclusion of the other choice. And that simply is not the law in Arizona. In this case, what the word elect means is simply to choose. And when Justice Feldman used that phrase, elect to waive the security and sue on the note, he used it in conjunction, in reference to ARS 33722. A lot of people think of that statute as an election of remedies statute. And in fact, the title of the statute is election of remedies. But it is not an election statute in the sense that it requires lenders to choose either foreclosure or suing on the note. What the Supreme Court held a long time ago, in 1952, in Smith versus Mangels, is that a lender with security has two separate and independent rights. You have the right to get paid by suing the borrower personally, and you have the right to get paid from the sale of the mortgage property. But you can exercise either of those rights independently, you can exercise both of those rights, or you could do neither. You could do them in any order that you choose. You don't have to do one or the other. And all that ARS 33722 says is that you cannot maintain two separate lawsuits, one lawsuit suing on the note and one lawsuit to foreclose your deed of trust, and have both of those actions pending simultaneously. But you can file a single lawsuit where you ask for both foreclosure and a suit against the borrowers for the balance of the promissory note. You could file a lawsuit for judicial foreclosure only. And then once you get that judicial foreclosure judgment, it becomes final, nobody's appealed. You can file a separate lawsuit on the note, or vice versa. You can file a suit on the note, get your final judgment, and then foreclose. 33722 does not require an election in the sense of you must choose one or the other to the permanent exclusion of the thing you've chosen not to do.
What does the elect to waive in Baker mean then?
The elect to waive in Baker means if you are the holder of a non-purchase money deed of trust, you can choose to forego your right to conduct a trustee sale and instead sue directly on the promissory note.
But in just your earlier explanation, there really is no election. You're going after the note, and then however that comes out, then you're going after the deed of threat to housing election.
Well, respectfully, Your Honor, I'd say that there's an election in the sense that you choose not to complete a foreclosure before filing a lawsuit on your promissory note. Again, I think the meaning of the word election in that case is simply to choose, and it doesn't mean you choose this now, and that's a choice that you're permanently locked into, and you can never do anything else. To be sure, there are a number of states that have express election of remedy statutes. New York, for example. In that case, you can do one of two things. You can foreclose and take your security back, or you can say, forget it, I'm done, I'm not going to do anything with this security, I permanently release my right to foreclose on it, and you can sue on the note, and then you're barred from ever doing the other thing. But that is not the law in Arizona, and the Arizona Supreme Court and this court have consistently interpreted ARS 33722 as being not an election of remedy statute in the sense that you've got to choose one or the other, but simply as a procedural rule about what actions you can have pending at the same time. The interpretation that the appellants are urging this court to adopt from that language, elect to waive and sue on the note, is not only not found in the language of, is not only not an interpretation that can be derived from Baker versus Gardner, but it's also an interpretation that's completely contrary to this court's precedent in Tolliver. And I did hear during the opening argument this reference to ARS 12-1566 as saying, if you want to waive your deed of trust, you have to record a release and reconveyance. Well, first of all, it is true that they never cited ARS 12-1566 at trial, and I don't believe they cited it in their appellate briefs either. So to the extent they wanted to rely on that, they've waived it. However, what Tolliver says is that ARS 12-1566 confers no substantive rights on borrowers whatsoever. It simply says, if you want to pursue, if you don't want to foreclose, you don't have to. It doesn't confer any substantive benefit on borrowers whatsoever. The other holding in Tolliver that is critical is that not only does a lender that is not subject to the anti-deficiency statutes not required to record a release of its deed of trust before suing on its note, but that to impose such a requirement on a lender would be inequitable. All you are doing in that case is conferring a windfall on the borrower by depriving that secured creditor of its security and converting it into an unsecured creditor and forcing it to give up one of the rights to which it is entitled as a secured creditor without any real benefit to anybody whatsoever.
Counsel, waiver aside, is it your client's position that 12-1566 has anything to do with this case?
Absolutely not, Your Honor. As I think you noted, ARS 12-1566 applies only in actions to obtain a deficiency following a trustee sale foreclosure or in a mortgage foreclosure situation. The real thrust of that statute is to give people who've had their properties foreclosed on and the lender that's foreclosed is seeking a judgment to give them a credit against their debt equal to the fair market value of the property. In this case, Compass never foreclosed. It didn't do anything to foreclose on its deed of trust. As a result, not only does the statute not apply, but there's no fair market value credit to which they're entitled because we didn't take back any security. That security was wiped out when the senior deed of trust holder foreclosed. And as the court also noted, that happened just 20 days after we filed our lawsuit. So 20 days into this lawsuit, before we moved for summary judgment, before anything has really happened, and I believe before they even filed their answer, we've now had our deed of trust extinguished as a matter of law. What is the practical benefit of saying, you've got this deed of trust. It's about to become completely worthless because there's a trustee sale that's already been noticed up, and it's going to go forward. But still, you have to do something to affirmatively release your deed of trust or you can't sue. There isn't any. There simply isn't any benefit in doing that. But if you were to force a lender to do that, you are going to be seriously prejudicing its rights. What would have happened, for example, if the Bennetts had cured their default on the senior deed of trust before Compass had obtained its judgment on the note? At that point, the senior deed of trust is still in place. Compass is now an unsecured creditor. It's lost the entire security that it's bargained for. And what benefit does that serve? What if the Bennetts had waited until the day before the trustee sale took place and then filed bankruptcy? In that case, again, we would be relegated to the status of an unsecured creditor and likely would recover nothing, or at best, pennies on the dollar in that bankruptcy case. And finally, what would have happened if the first deed of trust sale produced excess proceeds? What if there were $300,000 more derived from that sale than was necessary to pay off the first deed of trust? Well, one of the things that we bargained for as a junior deed of trust holder is a right to obtain the excess proceeds from that sale. If you force us to give up that right, now we're losing our right to obtain those excess proceeds, and in fact, the borrowers are harmed because rather than us applying that $300,000 to their debt and saying, your indebtedness to us is now reduced by that $300,000, they owe us just as much as they did prior to the trustee sale. It simply doesn't benefit anybody to impose such a requirement. And lastly, Your Honor, I would note that what makes the appellant's argument even more illogical in this case is their acknowledgement that under Baker, Compass could have chosen to judicially foreclose its deed of trust and still obtained a deficiency judgment against them. That was one of the that was one of the things that Justice Feldman expressly said in his supplemental opinion. If you are the holder of a non-purchase money deed of trust, you can choose to treat that deed of trust like a mortgage, foreclose it judicially, and because you are not subject to the purchase money language of ARS 33729, you also have the right to obtain a deficiency judgment against the borrower. So if this court were to adopt the interpretation urged by the appellants, you simply can't square that with Baker, because how can you foreclose on a deed of trust that you're required to give up as a condition to suing on the note? For that reason, the appellant's argument is not only unsupported by Baker, but expressly contradicted by it. And accordingly, because there are no other defenses, and they've acknowledged that there are no other defenses to Compass's lawsuit, and because there is no rule in Arizona that supports the interpretation of Baker as requiring an affirmative obligation on the lender's part to release its deed of trust before suing on the note, we respectfully request that this court affirm the judgment in favor of Compass. Thank you.
4 seconds.
We'll give him 2 minutes to.
Thank you, Your Honor.
As we ask questions.
So I'm going to take some of these issues out of order, but I note that if we admit that Compass could have done a judicial foreclosure, and in a judicial foreclosure we would have had all of the statutory protections afforded us under the law, including the right to a fair market determination in the calculation of the deficiency. Those are due process rights. Those are substantive statutory rights that we do not have if they sue on the loan. If they sue
Can I go back to just kind of the original argument?
Yes.
If, in your view, if Baker had not used the term elect to waive, if it had just said the borrower may waive, then you're okay with would the lender be waiving simply by pursuing a lawsuit? Is it just the word elect to waive?
No, it's the phrase elect to waive. I don't believe the word waive alone would change our application here, or elect alone. Well, elect to sue, I guess, would be different. But any time they use the word waive the security.
Then doesn't waiving the security, can't you do that in a number of ways that we've suggested without filing a formal document? So you're saying elect to waive means something different than waive.
I'm saying waiving the security means something, as opposed to what occurred in this case. The lender preserved their security throughout the existence of that deed of trust. The lender sued on the note, and while it was pursuing a judgment lien through the courthouse, it held all of the rights that arose from the deed of trust security instrument. There was no waiver of the deed of trust.
So your argument doesn't hinge on elect. It's the concept of waiver that's the basis of your argument.
Well, if I understand the question, I guess yes. I mean, waiver of the security instrument is the key concept here. They had to make an election. And so that's something that the courts, that's something the Supreme Court has said, that it's not just do a trustee sale, which, by the way, 814G covers both purchase money and non-purchase money obligations, so that's not an issue there. It's not just pursue a judicial foreclosure, which still involves the note in determining what the amount of the debt is, but has all of those protections. The third option is to elect to waive the collateral, elect to waive the security, and sue on the note. Those words mean something because the Supreme Court cited that language repeatedly, and this court cited that language repeatedly in RTC versus Siegel. And as to the Tolliver case, first, it's important to note that the Tolliver case is an apartment complex. It is not covered by the anti-deficiency law. The Tolliver case, though, which is where the 12-15, whatever is cited, is important not because we're relying on that statute. That statute is part of the Tolliver decision, which is instructive in the concept of waiving security, right? That's the relevance of Tolliver. Tolliver and the case cited by Smith are not anti-deficiency cases. They do not fall into the 2.5 acres or less single or double family home. Their holdings are somewhat meaningless to why we're here today. It is the Supreme Court and RTC versus Siegel. And one last note. If the supplemental decision that requires the lender to elect to waive their security is dicta, if it doesn't mean anything because it didn't change the holding with regard to the parties in the case, then the supplemental decision doesn't mean anything. If the supplemental decision does not mean anything, we stand before you today with the holder of Baker versus Gardner in the original opinion controlling law. And if that's controlling law, Compass never had the right to initiate this lawsuit in the first place. It can't be both ways. The meaning of the Supreme Court's supplemental decision can't give the lender the right to sue, but then the lender turn around and not expect to live by the language the Supreme Court set forth when it gave them that right to sue. Either the supplemental opinion controls and they need to waive their security, or the supplemental opinion does not control and their lawsuit is barred by the anti-deficiency law. Thank you, Your Honors, for the additional time and for the hearing. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. And with that, we'll take a short recess before our next case.